Welcome, everybody. My name is Steve Wormiel. I'm a past chair of the ABA section of Civil Rights and Social Justice and current chair of their Free Speech and Free Press Committee. And we are bringing you this webinar on the topic of is religious speech free speech? Let me say a couple of things to set up the discussion today. First of all, we're thrilled to have the ABA sponsoring this discussion. The ABA section of Civil Rights and Social Justice sponsors many webinars. And if you're interested in looking at other events and topics, please go to americanbar.org/CRSJ, and you can see all the different programming taking place. A couple of housekeeping items. We will try to make time to answer your questions. If you put them in the Q&A, please do not put them in the chat. Please use the Q&A feature. If you're not sure where the Q&A feature is, if you activate your screen so that you get the pop-ups at the bottom of your screen, if you click on more, you will see the Q&A feature there. And again, please use that to pose your questions. We are making a recording of this program. It will be shared on the website for this program, as well as on the YouTube channel that the section of Civil Rights and Social Justice maintains. And so you can share it with friends or refer other people to the recording as well. With that, let me jump in. We're here, as I said, to talk about is religious speech free speech. I want to thank my friend and colleague, Richard Fulton, who is one of the chairs of the section's Religious Freedom Committee, and he helped organize this panel and line up some of the speakers, and I hope is listening in. The topic really is a way to try to get us to think about when the Supreme Court treats speech about religion as free speech like any other speech, meaning it's subject to non-discrimination principles. The government can't discriminate on the basis of the content of the speech. And when the Supreme Court treats religious speech as involving one's individual right to free exercise of religion, and what the interplay is of those factors. We're doing this panel partly because it seemed to some of us, at least, that there has been an uptick in the volume of cases raising this issue. Recently, in the chat, you will find an introductory little memo describing a few of the cases. It's also on the website for this program. And our panelists will be referring to some of those cases. Let me introduce the panelists and let's get them underway. In the order in which they will speak, first is Dan Mack. He is the director of the American Civil Liberties Union program on freedom of religion and belief, where he handles a wide range of litigation, educational programs, writing, and speaking about issues of religious freedom. He's also an adjunct professor at George Washington University Law School, and previously was a partner at the law firm of Jenner and Block. Our second speaker will be Holly Holman, General Counsel and Associate Executive Director of the Baptist Joint Committee, where she regularly provides expertise on religious freedom issues in amicus briefs, testimony, advice to Congress, public commentary, media interviews. She is also an adjunct professor at Georgetown University Law School and hosts a podcast for the Baptist Joint Committee, and previously practiced law in Nashville and DC. Michael McConnell is director of the Constitutional Law Center and a professor at Stanford Law School. He was a federal judge on the U.S. Court of Appeals for the 10th Circuit for 7 years. He has been a longtime law professor and expert in religious freedom, constitutional law, and other issues, and has worked both in academia and private sector and in the federal government. He's a prolific scholar, author, and appellate litigator. and has argued 16 cases in the US Supreme Court. And by no means least, but last speaker is Sarah Getz, Senior Counsel at Democracy Forward, which is a national legal organization advancing democracy through litigation, public policy advocacy, and more. She has previously handled litigation at Americans United for Separation of Church and State and the ACLU National Prison Project. Welcome, everybody. We're delighted to have all of you. Audience, I've asked the speakers to speak for about 10 minutes each, and then we will give them some opportunity to react to one another, and then we'll turn to your questions. So Dan, have at it.
Thanks, Steve. Thanks to everyone for joining us this afternoon. At the outset, I'd like to frame some of the issues that we'll be addressing. In particular, it's worth remembering, I think, that our topic today is not entirely new. In fact, a good bit of our constitutional history has involved this interplay between religious exercise and free speech. Much of what we now regard as core civil liberties protections came in lawsuits involving the Jehovah's Witnesses, who in the 1930s and 40s alone brought a couple dozen cases that made it to the Supreme Court, often in what would turn out to be seminal decisions. These include cases addressing not just the substantive rights of speech, press, and religion, but also the concepts of federal judicial authority over the states, incorporation and application of the Bill of Rights to the states, and just overall broad judicial oversight of rights. Perhaps chief among those cases was the landmark decision in West Virginia versus Barnett, where the court in 1943 reversed itself from a few years earlier and held that objecting Jehovah's Witnesses could not be required to salute the flag and recite the Pledge of Allegiance in schools. The family's objections in Barnett were firmly grounded in their religious beliefs and practices, and their challenge did include both religious liberty and free speech claims. But the decision itself rested only on the speech claim. In fact, while acknowledging that the family's objections were religiously based, the opinion in Barnett made clear that it would have reached the same conclusion regardless of any religious motivation, famously identifying what it called the fixed star in our constitutional constellation, which essentially bars the government from demanding adherence to official orthodoxy in religion, politics, and other matters of opinion. So, fast forward about a half century, and we see another wave of Supreme Court cases, many of which sided with religious expression, but principally through the free speech clause. That focus on free speech was due, at least in part, to a shift in strategy by litigants who were frustrated by the Supreme Court's 1990 decision in Employment Division versus Smith. That decision severely limited the reach of the free exercise clause and essentially shutting down any claims for religious exemptions to laws that are neutral and generally applicable, even where those laws incidentally burden religious exercise. So in other words, if a law like the one criminalizing peyote use in Smith applies to everyone, religious and non-religious alike, and wasn't specifically aimed at punishing religious observers, there's no free exercise right to an exemption. After Smith, religious expression cases relied heavily on the free speech clause rather than the free exercise clause to do the heavy lifting. And the Supreme Court sided with religious expression quite often, giving religious speakers equal access to government forums like meeting spaces, and in some cases, subsidies, and characterizing government limits on private religious expression as a form of impermissible viewpoint discrimination. But even as it treated religious expression as a core form of protected speech, the Supreme Court still recognized an important guardrail, which is the Establishment Clause. It's one thing to protect private religious expression, which is a noble, vital constitutional right, but it's quite another to allow those in power to use the government, the machinery of government, to promote and favor their preferred religious beliefs. So in the public school setting, for example, the court has been careful to draw a line between government speech endorsing religion, which the Establishment Clause has something to say about and then generally forbids, and private religious speech, which is protected by both the Free Exercise Clause and the Free Speech Clause. So, for example, official school-sponsored prayer, say over the PA system during class or at graduation or at football games, was deemed by the court to be government speech subject to the strictures of the Establishment Clause. But I think the current Supreme Court is upsetting the long-standing balance that we had here and has shown, in some cases, active hostility to Establishment Clause arguments in recent years. That, to me, is a serious problem. And it raises some important questions in these religious speech cases. First, should private religious speech not only be protected, but actually privileged above other forms of expression, including even political speech? The court has said, correctly so from my perspective, that restricting private speech because of its religious character is not only content, but also viewpoint discrimination. But if that's true, then so is the converse. Religious speech shouldn't be elevated above other forms of speech either. Otherwise, there's a problem from a free speech perspective in favoring certain viewpoints, religious ones, over others, say purely political ones. And there's also an Establishment Clause problem, in my view, and in the view of the Supreme Court for many years, with the government actively privileging religious expression over all other forms. Another question is, can we and should we continue to distinguish between government religious speech, to which the Establishment Clause should still apply, and in my view, apply with real teeth? Should we distinguish between that and private expression? Now, I don't mean to suggest that there's any sweeping categorical rules about this, at least in thornier cases. It all depends on the facts of each situation. So take, for example, the recent case of Shurtleff versus Boston. That's one of the cases that's in the summary, I think, that has been linked. In that case, a religious group called Camp Constitution was denied permission to fly its Christian flag in front of City Hall. Now, some people assume that, of course, we, the ACLU, would side with the city. After all, wouldn't we have a problem, an Establishment Clause problem, with a big religious display right at the seat of government? And in most cases, yes, we would, as we did in the past with all sorts of government displays of 10 Commandments, nativity scenes, giant crosses. But once we delved into the unique facts of the Shurtleff case, we ended up supporting the Christian group. Why? The circumstances suggested that the flag that they wanted to fly would be clearly private speech, and therefore not attributable to the government. Why is that? Now, basically, the city has 3 flagpoles in front of City Hall, and it has designated one of those essentially as a public forum for fleeting displays by private parties. So if you look at what happened throughout the history of that case, for more than a dozen years, the city had approved almost 300 requests to fly all sorts of private flags on that flagpole, and had never rejected a single one. It was essentially come one, come all. And the display that was being requested there was a fleeting one. The group asked to fly its flag just for 1 hour total on one day. And the Supreme Court ultimately agreed in a unanimous decision that the city's denial was a free speech violation, that this was essentially a form of a public forum, and that the city couldn't exclude the Christian flag. So that's one case where we at least concluded that there was no concern, no establishment clause concern. But as a general matter, I think this current court has gone way too far in privileging religious expression while essentially ignoring vital church-state concerns. In the Kennedy versus Bremerton case, for example, the Supreme Court ruled in favor of a public school football coach who claimed a right to pray on the 50-yard line after games. Now, this was after a history that he had of doing so with his team, both on the field and in the locker rooms. Now, there was a significant dispute about the record in that case, and I, for one, at least share the lower court's view that the coach's side in the case spun a deceitful narrative. But that narrative was ultimately adopted wholesale by the Supreme Court majority in the Kennedy case. So despite what I think was strong evidence to the contrary, the court pretended in its decision as if the coach's prayer was personal, quiet, and private, that it fell outside of his official responsibilities. He was on duty, everyone concedes that, but they said it fell outside of his official responsibilities. It didn't involve students, and it wasn't imposed on a captive audience. I think in that case, the school district had valid concerns, not only about the perception of religious favoritism by the school and the coercion, the religious coercion of players who might feel pressure to join their coach in prayer, but they also had valid concerns about the considerable disruption that was caused by the coach-generated spectacle at football games. The Supreme Court, though, in the case was dismissive of such concerns, and in ruling for the coach, gave religious expression a privilege I think it almost certainly would not afford other speech by public employees. Now, before Kennedy, the court had never upheld a free speech claim of a public school teacher, or a coach in this case, to speak on school grounds during working hours while on duty against the wishes and rules of the public employer, in this case, the school, particularly with that kind of record of actual disruption. Even as the court has limited free speech rights of government employees while on duty generally, religious speech by government workers seems to be getting a free pass. Now, there's a more limited reading of this case, which again requires accepting the court's description of what supposedly occurred. Again, no captive audience, no students involved, that sort of thing. But the case can also be viewed as the latest in a series of troubling decisions that elevate religious exercise and expression above other important constitutional protections, like the Establishment Clause in Kennedy, not to mention other important considerations like anti-discrimination protections. And I think I'll stop right there. I suspect some of my fellow panelists may address those issues. So I will leave it there. Thanks.
Thank you, Dan. Holly, you're next.
Thank you. And thanks to all my panelists and to the organizers for organizing this today. And I'll have a few things to say, and then I'll really look forward to the conversation. As noted, I serve as general counsel for the Baptist Joint Committee for Religious Liberty, and we come to these issues out of a historic Baptist perspective that cares about the religion clauses and the separation of the institutions of religion and government, because it has been good for religion. And I appreciate Dan giving all of that background about the relationship between free speech and religious liberty from those early cases. And the way that I would say we come to this, first of all, in the broad question that's presented by the title about the relationship between religious speech and free speech, they're in two different ways. First of all, I think as people often think about religious liberty, they first just think of the first 16 words of the First Amendment. And that's where most of BJC has spent our time and developed our expertise. It makes sense to think of religious liberty being protected by the promise of the free exercise of religion and the government not advancing religion, the government being restrained by the Establishment Clause. And these clauses work together for to protect religious freedom. But of course, as some of what Dan said illustrates, the free speech clause plays an important role in protecting religious speech and thus religious freedom. It provides an additional restraint on government interference with religion. And I think when people often think about the freedom of religion, you often think about religious expression very broadly, maybe in religious worship, which of course often includes religious speech, but also in individuals' action, being able to talk about your religion, to convince people to join your religion, to proselytize, or to educate people about your faith, to spread the faith. All of these are ways of protecting religion and show the overlap of free speech and free exercise or religious liberty concerns. The second way I think about it, it's been touched on a little bit, is this line of cases in religion law where free speech principles show very clearly how religious speech cannot be discriminated against or treated differently in certain kind of forum, where the government sets up ways that we come together in society as individuals in all our religious diversity, and having opportunities to participate in these forums. We should not be left out because of religion being somehow disfavored. And I don't believe that the Establishment Clause, as has been traditionally interpreted, requires that. So that we have long lived with and understood cases that where the government provides an open a forum or space for individuals or groups to come in and have access to the forum, that in those situations where the facts show that they are acting as individuals and not as the government, free speech protects that right. And often those cases were brought with challenges from on the Establishment Clause side, but eventually came to pretty clear understanding, certainly something that we as a religious organization would support and articulate as we realize that no one owns the one religious voice in this country, but we all have to share these public spaces and should be able to do so as equal citizens and should not be disfavored just because we approach issues from a religious perspective. So with those two notes about generally how, of course, religious free speech protects religious speech, the question that's on my mind and or on people's minds that often come to me is what's going on with the court now. There has, as Professor Wormiel mentioned in the beginning, been a substantial uptick in the amount of cases dealing with religion that this court has taken, and many of them do deal with this interaction of free speech and religious liberty. And I would just make a few comments to add to some that we've opened up, particularly about a little bit about Shurtleff, but then more about the Kennedy case. For us, we did not file a brief in the Shurtleff case. It clearly fell into this stream of thinking for us that once we looked at the case carefully, that the government had opened some kind of forum or had it appeared almost accidentally opened a forum because it was quite unusual for it not to be a government speech when you're using a flagpole in the context of a government building. And I mentioned that because, as Justice Breyer's opinion said in that 9-0 decision in Shurtleff, the question first is it government speech or individual speech? And you answer that question by looking at all of the facts. But indeed, as has been explained, that one of the flagpoles was used commonly for individuals and had been used without a lot of monitoring by the government, without indication that the government was, in fact, limiting it in a way that it was having outside speakers speaking for the government, but instead had been quite open. And as that case made clear, that doesn't mean that Boston or any other city had to create that kind of forum or would do so in the future. One thing that I thought was very interesting about that case and how it was argued, and then how the concurrences were written, was that it really shows in the concurrence, particularly Gorsuch concurrence, this stream of thinking that kind of is, I would say, not only dismissive of Establishment Clause values, but in a way really misunderstands them, exaggerates this idea of it only operating as a hostility to religious voices, as opposed to an essential protection for individuals and religious communities in matters of religion. And as we see that from later Gorsuch opinion, there is a certain thinking about the Establishment Clause is much less valued by members of the current court than it has historically been. And I think that that's not the good news for religion that some people might perceive it from the kind of rhetoric in that decision. So following after putting the shirtlift decision aside, which I said in the end agreed with the opinion, because it was based on that first basic question that the court recognized, which is whether the flag raising program constituted government speech, and that sharp distinction between individual and government speech. I want to move on to the Kennedy case and what's so difficult about that case for us, or troubling about the case. We filed a brief on behalf of the district in Kennedy versus Bremerton, not because of any disagreement with the idea that an individual public school teacher or coach has some free speech and even free exercise interests, but because the context is so important to how that is exercised. Unlike students, teachers in public schools are individuals, but unlike just individuals that are on campus and have some individual rights, they also are typically agents of the state and they should be looked at as such. As Dan pointed out, in this case, the court took a long story, as most employment stories are, a detailed story focused on singular facts that to uphold the free speech claim of Coach Kennedy. On the positive side, the court's decision in some way can be seen to limit those facts, that his free speech rights could be seen akin to a teacher's rights to pray alone outside of her students, as a teacher might in the teacher's lounge or before lunch, or even in front of others, but in a brief, quiet manner. What's different about this case is that the court ignored the context and the long pattern and practice of Coach Kennedy that would justify the school district's disciplining of Coach Kennedy. And I say this is really disappointing in that religion in public schools is one area that had long been seemingly settled in our understanding of how free exercise and no establishment work together to provide religious freedom for all, and a great amount of religious freedom and religious diversity that we see in public schools felt safe and protected. And according to agreed upon guidelines at the federal level, cases and statutes that kind of recognize the distinction between those in authority and the individual students. As we advocated in that case, we cited the cases against school-sponsored prayer that's long been recognized as unconstitutional, and the court's holdings that nothing the court has suggested suggests that a school could persuade or compel a student to participate in a religious exercise. And we would posit that that's still the case, that Kennedy should not be seen as allowing any kind of coercion or persuasion of students. And in fact, the court's isolation of the facts, should be taken very seriously to ensure that it's not used to coerce students. But it's disappointing that the court gave such little attention to the role of the coach and his past practice and influence over students. As we put it, the government, of course, can only act through human beings as its agents. And the Establishment Clause means nothing unless it binds people acting on the government's behalf. And that was very important to us. I think it's very important going forward. We're happy that the federal guidelines that have been reissued after the Kennedy case continue to hold that line. But of course, the implications of it are not only that many people will misperceive the extent of an individual free speech in public schools when they have heard about the Coach Kennedy case and they've seen the photographs of him praying with his players. But the court also used that case to then abandon the lemon test that had historically and often used on and off in Establishment Clause cases, to abandon that, leaving very little guidance for the future. So those are the reasons that we were most concerned with the case, and are watching in lower court cases to see how that develops, and hoping that the court does not continue to expand and focus on free speech rights to the detriment of the important guardrails that the Establishment Clause has played in protecting religious freedom for all. With that, I will stop and let the next speaker go.
Thanks so much, Holly. Michael.
Thank you, and thanks for inviting me on this program. When I first was invited and was told the topic is religious speech, free speech, I have to say I said, I don't understand what this program is going to be about. Of course, religious speech is free speech. As Dan points out in reference, he mentions the Jehovah's Witness cases. We wouldn't have an active free speech clause if it wasn't for cantankerous people like the Jehovah's Witnesses, who insisted on their right to be able to speak even when it annoyed other people. And you can go back even before that. The first sustained philosophical argument in favor of freedom of speech was John Milton's Areopagitica, and that was primarily in defense of the right of religious dissenters to be able to speak and publish religious views that were contrary to the norm. So of course religious speech is free speech, but religious speech does present, as the two previous speakers have said, some interesting boundary questions, because when you look at the First Amendment, we have several different clauses. So we have the free speech clause, which treats all content and viewpoint equally. So religious speech is on an equality plane. We also have the free exercise clause, which treats the exercise of religion with a degree of protection that isn't given anything else. So we have free exercise of religion, not of everything. Now, religious speech is part of free exercise. Holly mentioned, worship services. Speech is an important part of worship services and an important part of a religious exercise. But there's also a lot of religious exercise which is not, strictly speaking, speech. And so, there are going to be some boundary cases where you wonder whether it's going to be the equality emphasis of free speech that dominates, or is it going to be the preferred freedom frame of free exercise, insofar as what we're talking about is some sort of mixture of speech and conduct. So, for example, the recent COVID worship cases. So you had churches and synagogues and religious groups suing against the shutdowns under COVID. And the question is, who do we compare them to? And, when the state of Nevada is allowing crowded casinos to operate full blast, but not allowing churches and synagogues to operate and, with social distancing and various restrictions, that becomes an exercise case, because it's not primarily about what people say. I don't even know what people say in casinos. But other than "I'd like another drink, please," it's about meeting and so forth. And so religious meetings, that is to say, worship services, were protected because they were being treated less well for their exercise than comparable secular contexts. But sometimes it's going to be difficult to tell which of whether free speech or free exercise dominates. And then we have the Establishment Clause, which, as both Holly and Dan have been talking about, involves government action and government speech. And so we have this interesting idea, which I'm not disputing. Interesting isn't a complaint, but it is interesting. The government is free to speak, even controversially, on most topics, but not religion. So, government is not, under the Establishment Clause, the government is not a participant in debate or explication or advocacy with respect to religion. But that doesn't mean that within all government spaces that private people can't speak. And there are difficult questions, but for most of, I've been litigating and writing in this area for a long time, and during most of that time, the cases were about bogus claims of establishment that were keeping individuals from being able to speak freely just because their speech occurred in government context. So for the first cases I ever litigated, I had to do with high school students who were being forbidden to meet. They couldn't have Bible study clubs, even though you could have an environment club and a gay rights club and a Democrat club and a Republican club and a tennis club and a debate club and every other club in the world. You couldn't have the students couldn't form a Bible study club. Why? Because it was on school property, and there was sort of the sense that, well, maybe the Establishment Clause somehow kicks in. No. Just because it's on government property does not mean that it's government speech, and eventually we prevailed on that. But there are going to be difficult questions on the margins. The Kennedy versus Bremerton case, this football case, is, I think, one of those difficult problems, because teachers, as Holly, clearly said and correctly said, teachers are the agents of the school. And if they are using their official position as teachers of the school to inculcate religion, that's a violation of the Establishment Clause. But, teachers are also individuals. And much of what they say, or parts of what they say, not in part of the formal curriculum, but, as human beings and employees within the school day, teachers do say things that are on them, right? You can have a Jewish teacher might be wearing a yarmulke, a religious indication, or a Sikh teacher might be wearing a turban, or a teacher might offer a grace before eating lunch, even though other people, students might see that, and they might even be influenced by any of these things. There was a case in my court about a teacher that had one of these silent reading periods where the students could read whatever they wanted for half an hour, kind of like in the Ramona books, and the teacher chose to sit at his desk and read from the Bible, and he was told he couldn't do that because it would somehow be an Establishment Clause problem. So teachers are difficult. And this particular case was difficult but it wasn't difficult for the legal principles. I didn't hear anyone, including, Holly or Dan, complaining about the legal principles. It's their reading. It was, what were the facts of the case? And I heard, well, the court pretended this, that was Dan's verb, or the court ignored that. Let me just say, don't give the court a little bit of credit here for being precise lawyers, because they decided the case that was put to them, because there was a lot of bad stuff, establishment violations in the past. They had been worked out, and Coach Kennedy had agreed that he would not do those things. And as the case came to the court, the only question was whether he could pray silently after his team was away from the field, off somewhere else, out of view, doing their, fight songs or something or other like that. Now, that is not the way it had been for the last several years, but that's the way it was at the time when Coach Kennedy received the reprimand that was at issue in the case. Now, maybe our legal rules should allow, more of an emphasis on things that used to be, and maybe the context should be better. But the court decided the precise legal case on the precise facts that was presented to it. And when you read that, it was not a broad, it did not favor religious speech at all in any way. And I didn't read, I hear complaints that the opinion just was dismissive of establishment clause values. I didn't hear any quotes. I'd like to know, what portions of the opinion are you referring to? Because it seems to me that the court decided this narrow, recent set of facts according to perfectly normal free speech and establishment clause principles. We've also spoken of the Shurtleff case, the Boston flag case. I mean, it was a perfectly easy case. I'm interested that within the ACLU they had these debates, because it was unanimous in the Supreme Court, and there's been relatively little criticism of the decision that I have heard. Now, if I were running the city of Boston, and I'm not, but if I were running the city of Boston, I wouldn't let groups fly their flags over the city hall. I think that's a very strange thing. What are we going to do when the Ku Klux Klan wants to fly their flag in front of the city hall? It's just better not to get in the business of letting private groups, and then you won't have the religious group either. But there certainly is no privileging of religious speech. There should not be privileging of religious speech, and I'm unaware of any case recently that has done that. There were a lot of older cases that disadvantaged and discriminated against religious speech because of spurious concerns about establishment clause problems. Now, there is a kind of privileging of exercise, but that's baked into the very language of the First Amendment, which protects free exercise of religion, just as it prohibits establishment of religion. And those two concepts working together make sure that the government doesn't use its power either to encourage, incentivize, coerce the practice of religion, or the non-exercise of religion. And I think the main change in recent years has been for the court to be walking away from a couple of decades of decisions in which the Establishment Clause was allowed to swallow up all the rest of the First Amendment.
Thank you, Michael. Sarah.
Thank you so much, and so pleased to be joining you all for this conversation. The ascendance of free exercise rights, I think, whether couched under the Free Exercise Clause or the Free Speech Clause or both, has corresponded with a concomitant weakening of the Establishment Clause, and principally the third-party harm principle, a long recognized Establishment Clause principle that when government makes third parties bear the costs and burdens associated with exempting religious exercise from a law, that amounts to an impermissible favoring of certain benefited religious beliefs over the beliefs and interests of non-beneficiaries. I think what's missing from the Supreme Court's recent opinions, and maybe most acutely in 303 Creative, though not exclusively, is meaningful consideration of the effects of enlarging the religious exercise rights of certain litigants, the effects on other populations, on LGBTQ people, religious minorities, and the public at large in some circumstances. And I think that even if the Supreme Court cases are conceived of as fact-bound or narrow decisions, I think one sees that litigants and some lower court judges are more emboldened than ever to assert and to recognize broader claims brought by those seeking to discriminate and to be exempt from laws by which the general public is bound, regardless of the impact on others. So to that end, I thought it might be interesting or useful to highlight a few examples of kind of what's percolating in some of the lower courts to show how some of these principles are playing out on the ground. To start with sort of the most predictable, both before and after the decision in 303 Creative, a number of wedding vendor cases have been winding their ways through the courts. Right now, for example, there are cases pending in the Second Circuit and the Sixth Circuit by wedding photographers who wish not to serve same-sex couples. The district courts in those cases reached opposite conclusions, and no doubt more to come in that realm. And while I don't know how much it's actually reached the courts, but I think we can imagine an expansion into other types of public accommodations. Shortly after the decision in 303 Creative was handed down, a beauty salon owner in Michigan announced that the salon would refuse to serve transgender, non-binary customers. As far as I know, litigation hasn't followed from that announcement, but it's not too much of a stretch to imagine that various business owners feel similarly emboldened by the outcome of that case. There's been a lot of talk already of schools, and there are indeed a great number of cases today concerning teachers, parents, and students' rights in schools, including challenges by parents and parent organizations to school policies prohibiting bullying and harassment on the basis of personal characteristics, including sexual orientation and gender identity, and prevent prohibiting students from intentionally misgendering transgender students. So by way of one example, in a case called Parents Defending Education versus Olentangy Local School Board, the plaintiffs say that such policies require students to affirm the idea that gender is fluid, contrary to their deeply held religious beliefs. The Southern District of Ohio, in that case, has rejected the parents' free speech claims, and it's now on appeal in the Sixth Circuit. There have likewise been a number of challenges by teachers to school district policies that would require them to use students' preferred names and pronouns, and teachers contending that doing so violates their speech and free exercise rights. Here, a number of district courts have held that teachers are likely to prevail on these types of claims. In one case in the Central District of California, a teacher who was fired for both proselytizing in class as well as refusing to adhere to her school district's policies on pronoun use has asserted her right to do so under the free exercise clause as well as speech clause, contending that this religious expression is fully protected by the First Amendment. To offer one other example, just last week, a federal district court in Colorado held that a private religious school was likely to prevail on its claim that forced adherence to Colorado's anti-discrimination requirements, which here was a condition on the schools participating in the state's universal preschool program, violated the school's free speech rights. The school had objected to the requirement that staff use both students and employees' preferred pronouns. And the district court in that case relied in part on the holding of 303 Creative in reaching its determination. To offer one other sort of interesting category where we've seen speech and exercise claims arise, the realm of crisis pregnancy centers. There have been a number of recent challenges by crisis pregnancy centers to state laws that prohibit them from disseminating false or misleading information, engaging in deceptive advertising regarding their services. Litigation is ongoing now in at least 3 federal district courts. And in 2 of these, the plaintiffs are faith-based organizations that contend that the laws in question violate not only the free speech clause, but also their free exercise rights, contending that their religious beliefs compel them to counsel pregnant women against seeking or obtaining abortion care or certain reproductive health services, among other things. So I'll spare, going through the litany of cases percolating in the lower courts, but suffice to say, there's a lot of activity. And the foregoing are just a couple of areas where we're seeing the trajectory of the Supreme Court's recent jurisprudence playing out with respect to public accommodations in schools, in the regulation of commercial activities, and in the employment context. And offer just a few kind of takeaways from my perspective. I think, first, as I mentioned earlier, a receding establishment clause framework around some of these cases means that the third-party harm principle is lost, and it shouldn't be. Courts have repeatedly recognized the grave harms that discrimination conveys. Going back to some core civil rights cases of the 20th century, recognizing the stigma and the deprivation of personal dignity. And certainly we saw that in the language of Masterpiece not so long ago. Relatedly, I think that the posture in which some of these cases are coming before courts exacerbates the issue, and really has the ability to shape whose rights are considered and whose are not. So when you have a pre-enforcement challenge brought by the owner of a small business, for example, who objects to a particular law, the framing is kind of business owner with religious convictions versus big government or unwieldy bureaucracy. But in those cases, the rights and interests of the LGBTQ people who stand to suffer when they're denied participation in the marketplace or unable to procure goods or services, that's not accounted for. That's lost. Second, and I know Holly touched on this, I think that these cases sometimes contain or court a false narrative that we're talking about expansion of free exercise rights or broadening of religious exercise rights versus LGBTQ rights, or being for broad religious exercise versus against broad religious exercise. But that's really not right. I mean, given our pluralistic society, there are a great many religious traditions and believers whose religious views are supportive of anti-discrimination laws, and whose views dovetail with those laws rather than oppose it. But I think beyond that, when anti-discrimination laws are watered down, it stands to harm religious liberty. Such laws generally prohibit not just discrimination on the basis of sexual orientation or gender identity, but also religious discrimination. And so, free exercise exemptions for religiously motivated discrimination on the basis of gender or sexual orientation also necessarily permit businesses to deny services to people who of the wrong religion or interfaith couples and so forth. And so I think it's a disservice to kind of frame those as oppositional. And maybe lastly, I think it's hard to see how to draw lines in some cases. I think a central feature of oral argument in some of the public accommodations cases has been about distinguishing between religiously motivated discrimination on the basis of sexual orientation and religiously motivated racial discrimination. I think the latter is still sanctionable under the law, but it's not clear, it's not clear sort of whether that line will hold or why indeed there should be a line there. And so I'll stop there and turn it back to you.
Thank you, everybody, for very insightful and I think provocative comments. I have one thought. I don't want to dominate the direction of the give and take, but I'll just throw this out and then maybe everybody can respond to each other, but sort of keep my question in the mix. 40 years ago, a Supreme Court justice whose biography I wrote and for whom Michael clerked used the metaphor that we ought to be thinking about a wall of separation between church and state, and added the thought that wall ought to be kept impenetrably high. Does that metaphor have any value anymore? It certainly doesn't seem to be impenetrably high. Does it even hold anything 40 years later, or is it a dead letter? But again, just throw that in the mix and I'll let you all kind of have at each other. Who wants to go first?
Well, I will. The word separation certainly still has an importance in our tradition, if not just in the minds of Americans, not just in the minds of Americans, but I still think in the law, and it would take a much longer webinar for us to, talk about all of the examples, including in ways that mostly protect religious institutions in defining themselves. The idea that that religion is somehow distinct and that institutions should be separate. I think you can find still some law that holds to that. Less so in the, as you were noting, in the Establishment Clause arena. So maybe we never had a wall, but we always had some degree of separation. And I think the wall, I don't think was ever intended to be hostile toward individuals, religious individuals and religious communities, as it was often attacked and continued from that citation all the way through today. So I think the separation is still an important concept, though the court doesn't talk about it. And I was curious and thinking about two things I want to respond to my co-panelists here. First, Sarah, thank you for pointing out both how protected categories that we seem to have so many fights now about non-discrimination for LGBTQ people, but the same concepts of non-discrimination affect other protected categories, including they protect against religious discrimination. And that's just one of many reasons that people might care about upholding non-discrimination, not creating an exemption routine, an exemption system that can do away with non-discrimination, make it too easy to get around it. And also, I think it's important to note that as you do, that there is such religious pluralism, religious diversity between different religions and within them on matters of human sexuality. And it's important that we really avoid that frame of religious liberty versus non-discrimination. I was also thinking about Professor McConnell, your comments, and I appreciate some days when I feel like I've been doing this work so long. I know you've been at it a lot longer than I have, and hearing that history of having to fight against what seem, and we might all agree, were understandings of the Establishment Clause that were unfair, that that no one would stand by today as far as how individual religious speech was treated. And I wonder if you would acknowledge that maybe that some of the old narrative needs to be let go of, needs to be abandoned, or at least needs to be tamped down. And I can acknowledge that disputes arise in different places. Maybe there are geographical differences, political differences, and where these disputes arise about who's being treated unfairly. But in these recent cases we're talking about, in the Kennedy case, we were talking about leading in not just religious expression, not just religious speech, but leading in religious exercise. And that had been the pattern. And that's pretty important. That's not just some teacher who was disfavored or treated wrong, differently because he said something religious. And likewise, in 303 Creative, we heard so much about the need to protect the business owner and the business owner's speech. Yet the narrative did not really sound right that people were hostile to religious differences about marriage or human sexuality. So I think these disputes are hard to see. These current disputes, to me, sound very different from what you described as a need to correct a balance from years ago.
Thank goodness things are different today. And, I don't know about narratives one way or the other, but cases are quite different. And I thought it was quite interesting to have Sarah, tick off a number of things that are percolating. And as to them, I think, some of them I thought probably the plaintiffs should win, and some of them the plaintiffs should probably lose, and some of them probably depend upon, factual details that that we don't yet know about. There are always going to be some new cases. Just to get back, so you asked me about a couple of, Bremerton and 303 Creative. I think rather than, what we ought to ask about is which practices, past and present, in Bremerton should be allowed and which ones should not. And I don't actually think any of us are in disagreement, or that the court's in disagreement. I think we can all agree that public teachers should not be leading prayers for their teams or their classes in the locker room. That used to be done. It's no longer being done. It was an Establishment Clause violation, and it's over. Now, what about coaches kneeling quietly, which is the case that the Supreme Court thought it was deciding, when their students aren't even present and don't even see it? I'm inclined to think that's protected. And I did co-author an amicus brief on behalf of some NFL players and former players. And the point that we made in that brief is that social practices like what people do on the athletic field need to be judged in light of, how things are understood. And what my football player clients wanted the court to remember is that in recent years, controversial expressions, often involving kneeling, have come to be understood as the personal expression of the player or the coach. So if Coach Kennedy had knelt during the national anthem instead of right after the game, I think everybody would be taking different sides, right? But they shouldn't. For purposes of free speech, it doesn't matter whether they are, making a racial protest or making a prayer. If it is private speech, it should be protected. And I think the court got it right on the particular practice they were describing. Now, 303 creative is not about a right to discriminate against people because who they are. It's the right of persons who are expressive professionals, artists, writers, dancers, maybe cake bakers under certain circumstances, maybe web designers. And the court, there was a stipulation between both parties. Both parties agreed that this web design was an expression, and they stipulated that it would be understood by people who saw the web design as being the expression not only of the client, but also of the web designer. And under those circumstances, to require a person to express something in support of an activity of same-sex marriage or anything else, it could be. Imagine this. Imagine a case involving a Jewish florist who is asked to prepare a special floral arrangement for the local church on Easter Sunday. Well, white Easter lilies are a symbol of the resurrection of Jesus Christ. And my guess is that most Jewish florists would say no, even if they are discriminating. They are discriminating, right? They would produce they would give a white lily under some other circumstances, but they are not willing to display white lilies on Easter Sunday in a church, because that would express a religious view that they, fervently do not hold. And in a free country like the United States, they should have a right to do that. And I'm sorry, I realize that it's insulting, for people to be told, no, I don't agree with you, and so I'm not going to lend my expressive services to support you. But sometimes freedom is more important.
Responses, thoughts, anyone?
I got lost in your hypothetical. I'm not sure if the florist was having to go in the church and provide the flowers and talk to the couple and bless the wedding.
They're just being hired to have a floral arrangement in the church on Easter Sunday. There's nothing complicated about the hypothetical.
I say that because there is a distinction between the amount of involvement of someone in a religious service. And there is probably distinction in businesses about how much it's a personal service that involves that kind of interaction versus a typical public accommodation, as in 303 creative. So I think that we would find some agreement on of course, there being some free speech limits on what a business owner is required to do. And you're correct to point out the stipulations in this particular case, but I do think that there's quite a bit of confusion about what would be a speech or a personal services kind of business where the business owner would be seen as speaking and providing services versus just providing public accommodation. But with that, I should point to Dan, who I think the ACLU did a very good job in their public commentary on 303 creative and the difference between the who and the what.
Yeah, and I think one of the, and I do want to return also to Steve's original question at some point, but just on 303, I think one of the main questions in these cases, it's not really, is the business expressive or not? And side note, when the court was trying to draw a line between expressive businesses and those that don't receive these protections as expressive businesses. During the argument in the Masterpiece Cake Shop case, the distinction completely fell apart. You had the bakery side saying that, of course, a baker is expressive, but an architect is not. Questions like that, I think, if that's where this turns, I think we're going to run into a lot of problems. Obviously, there are easy cases on the extremes, but there's a great difficulty in trying to decide which businesses qualify. I think the real question is, what is the aim of the government in passing its law and in enforcing its law? And if it is not aimed at the suppression of ideas, then at most, as expressive conduct, it has a lower level of scrutiny, sort of the O'Brien level of scrutiny. Now, in 303, the majority said that this deemed the state's interest to be in eliminating disfavored ideas and compelling an official state-approved message. I think that's absurd to think that this is the government's goal in passing civil rights laws. So, that's an important point to me. Is what is the government? What is the object of the government regulation here? Not how expressive is the content. And also, I will just throw out there as well on 303 that there are so many hypotheticals about artists and other individual folks who deal with expressive works. Most of them in these hypotheticals would not be considered public accommodations in the first place and would not be forced to do any of this. So yes, you have the stipulations in 303 that both sides agreed that this speech was somehow the business's speech, but I really don't think that makes sense. And in a case where that's not stipulated to, I think that's a real question. Returning to the separation with the wall, is there a wall of separation? I think there still is one. I think it's useful to think about it that way. I think the wall is slowly but steadily crumbling, but we still have it. Now, we heard about the importance, how religion is treated in very distinctive ways under the Constitution. There's a free exercise clause, which protects religious exercise in a way that other individual actions are not protected. But we also heard at the same time, of course, there's the Establishment Clause. So religion is treated as a distinctive category, but that goes both ways. And once you dismantle half of that equation, that's when I think you run into problems. I also think that there have been some messages from the court that not only do I think it's troubling that the Establishment Clause is in trouble, is in great difficulty, but it's unclear whether the court is actually engaging in an equal application of its guiding principles. So just to take one example, the court has been careful, including in the Masterpiece Cake Shop case, to rule out of bounds and unconstitutional government actions that show animus toward religion. In fact, the decision in the Masterpiece Cake Shop case rested entirely on the court's view that state officials were being hostile to the faith of the baker. But at the same time, right around the same time, the court gave then President Trump a free pass in upholding his Muslim travel ban, where he had expressed absolutely clear and unequivocal hostility to the entire faith of Islam. He said it many times, and the court was fine with it. So I think there's a danger not only in dismantling half of the two religion clauses, but also in applying guiding principles like equality when it comes to religion, in troubling ways.
I just say I agree with that. I mean, I think those two cases were reasoned inconsistently, and that was wrong. I think Masterpiece was correctly decided, but not because members of the commission said nasty things. It was rightly decided because under the law of Colorado, bakers were free to refuse to make cakes that would have disparaged same-sex marriage. There were 3 such cases. Colorado said that's fine. Bakers have a right not to express anti-same-sex marriage sentiments, but they don't have a right to refuse to express pro-same-sex marriage sentiments. So it's just straightforward viewpoint discrimination. I think the fact that the commissioner said some ugly things just was, may I say, icing on the cake.
We have other responses or comments. There are a couple of questions in the Q&A which we can turn to, but I don't want to preempt any other responses.
I was just going to respond briefly following from Dan on the question of the metaphor of the wall. I maybe view it as aspirational at this point, but I just wanted to add, in terms of dismantling the Establishment Clause, I do think, it's a disservice to government and to religion, and there's tons of language from the founding talking about the purpose of the Establishment Clause as being protective of both government and of religion, and of being a two-way street. That in addition to safeguarding against coercion and other related principles, it also protects religious organizations and faith leaders from intrusion of the government. And so I think that once again, the dismantling of the Establishment Clause, as we're seeing, has pernicious effects in all kinds of directions, including on religious organizations themselves.
May I just say I totally agree with that too. In fact, I just co-wrote, and this just came out a month or two ago, a book called Agreeing to Disagree: How the Establishment Clause Protects Religious Diversity and Freedom of Conscience. I am all in favor of the Establishment Clause. If they start dismantling the Establishment Clause, I will be the first to join you in objecting. But I think there is just no reason to say that. And I think it's you talk about emboldening. I agree, emboldening people to be making, extreme and wrongful claims. What is emboldening them to do that? It isn't the court. It's a bunch of people running around saying that the Establishment Clause has been dismantled. Please be more careful. People are listening to you. The Establishment Clause is just fine. You may disagree on the margins, and you might even be right on the margins in some of these cases that you would have decided them differently. But the core of the Establishment Clause is well and good. We cannot be required to attend a worship service. We cannot be required to give money to a worship. The government cannot control the doctrines or personnel of the church. The government cannot favor one religious denomination over another. These things are alive and well. Now, there's some there are cases where the facts are debatable, and we can characterize the facts one way or the other. And maybe Bremerton, I wish the Bremerton case hadn't come along, because it was one where the principles were not at issue, just the facts. Not a very good case for the Supreme Court to weigh in on. But all this gloomy talk is just scaring people, and it's emboldening other people.
But Michael, I understood you to be saying earlier that there were quite a few Establishment Clause decisions of a previous era that you thought were erroneous, which other people may have thought were at the heart of the Establishment Clause. So when you say it's not being dismantled, you're acknowledging that important Establishment Clause decisions that you thought were wrong have been overruled. You just don't think they were right or important, but other people might think they were quite important to the Establishment Clause.
Fair enough.
Yeah, that's basically what I was just going to say. I mean, it's alive and well if it means exactly what the conservative majority on the Supreme Court thinks it means. It's not alive and well if you think it means something more. And I do. Now, just to take one example of a thing that almost everyone agrees is prohibited by the Establishment Clause, is religious coercion by the government. Even there, in which the court in Kennedy itself said, yeah, no, we still think coercion is bad. You still can't compel people. The question is, what is coercion? In that case itself, there was actual evidence that students felt coerced to join the teacher in prayer. The court did not care at all about it. So even there, even something that we can all agree on as a general principle, in application, there is great disagreement.
But not because it was okay. It's because it ceased to happen. That's why the court didn't care about it. It's because it had already been ended.
Well, this is another thing on which we disagree, is how much, if at all, should courts take into account the history. And I don't mean the history as in, you know, our founders. I mean the history of a given conflict. At what point do we just wipe the slate clean and say, we don't care what he did yesterday, here's what he's doing today? In previous eras, the court found that to be relevant, and I think rightly so. Now they're saying, we don't care that he was violating the Constitution consistently for years, that he insisted on making a spectacle in the middle of the field right after games. We don't care about any of that. We're just starting from today, and we've forgotten what happened yesterday.
A fair point of disagreement.
All right, I'm going to ask us just briefly to turn to the Q&A. If all the panelists are able to open it, I don't know whether we want to respond to these or not, but are there any cases or other information that has addressed the rights of people not to engage in the exercise or practice of any religion? Anybody want to take that? Certainly there are, but anybody want to speak to it specifically?
Well, I think that is part of the core of the Establishment Clause. I think that's what the school prayer cases were all about. Every so often you get somewhat, fringe or debatable cases, like the question as to, there was a New Jersey case in which the transcendental meditation was being taught in the school, and the question is, is transcendental meditation a religion or not? That's probably a debatable point. I can't think of any cases in which there have been clear coercion where the courts haven't, have stayed their hand. Another interesting possible coercion case has to do with prison conditions, where prisoners are given an option for various types of rehabilitation program. And, some of those, like Alcoholics Anonymous, are, arguably quasi-religious. They refer to a higher power. And if that is like the best of the programs and the others are not very good, I think you might say that that's a coercive situation. But I think a lot of these are going to be debatable about the particular facts.
All right, we have a long question here, but if I'm not being presumptuous to the questioner, it seems to come down to whether a state court judge in Texas should be allowed to refuse to perform same-sex marriages as a matter of that judge's conscience, or does the State Judicial Commission have the authority to compel that judge to act? Anybody thoughts?
The first question I would have is whether in that system judges have a general right to recuse in cases where their consciences are implicated. So, if they can refuse to do other things, that I'm not sure what it would be, but let's say enforce, harsh immigration laws, or something having to do with capital punishment, or I'm straining to give realistic examples. If that's the general practice, then it should be the same here. But if judges have no leeway and they're forced to take every case, then this would seem to fall within that.
Anyone else want to weigh in? No.
I mean, I think it's pretty clear that clergy should never be forced to solemnize any marriage that they don't agree with. But when government officials start refusing to perform their duties, and an important question was just pointed out here about what are the facts there. But in other situations, not just judges, county clerks insisting on a religious right not to give out marriage licenses, even though that's one of the main parts of their job. I just cannot see the argument for allowing that sort of discrimination in the same way that we wouldn't allow it, as Sarah had pointed out, for a host of other forms of discrimination.
Michael, one aimed specifically to you. Can you confirm that you think 303 Creative's prohibition on compelled speech is limited to expressive services? The law has already gone further in terms of compelled expressive association and has found violations in the employment context.
303 Creative is certainly confined to expressive services. I'm not sure precisely what cases, expressive association, might seem to follow logically from that. But I do not think that it applies beyond expressive services. And even then, I think that there are some other limits implied by the stipulations in the case. So, for example, it was stipulated that there were ample other website designers who would be able to take the business. So the material, the argument that the state was really just trying to make sure that everybody is able to get important services seems to have been satisfied. There may be some other limits as well.
On the Establishment Clause being decimated, not entirely true to say that we are not being forced to give money to religious denominations. Government and taxpayers are being compelled to fund church-run schools through vouchers. Anybody thought?
It's bad to me too. So I've argued for this. So the rule is that if the government does not have to fund any private institutions, but if they fund private institutions, they can't discriminate against those that are religious. But they're not being given money because they're religious. They're being given money because they're educating students in conformity to the educational standards. They're accredited schools. And so, just as, students who get Pell Grants can go to Notre Dame just as much as they can go to University of Michigan, the same principle now applies at the school level.
To offer one thought on that point, I do think there's a mismatch or in the fact that on the one hand, religious institutions seek and sometimes many times get religious exemptions from anti-discrimination or various other laws. By the same token, they are also seeking and have largely been granted the same opportunities to participate in government programs and to receive participate in voucher programs, et cetera. And so it's both, kind of wanting to have it both ways of wanting participation on equal footing, but not wanting to abide in all instances by the same principles as others. And I sort of see some, unfairness there or imbalance.
I apologize. I have to run. I agree, though, with Sarah on that. But I wanted to thank our hosts and fellow panelists for this lively discussion.
Thank you, Dan, for being here. If the other panelists don't mind, about 2 more minutes. There's 2 questions left, and maybe we can try to take a crack at those before we wrap up. So, in light of recent court decisions regarding free exercise of religious liberties, you foresee forms of protest rather like kneeling during the anthem or refusing services to LGBT plus community eventually become such commonplace that the lines of free exercise and free speech are blurred. I'm going to guess that panelists don't foresee that, but anybody want to speak to?
That's not a legal question. I don't know what's going to happen in the future, but I think it's exceedingly unlikely that we're going to have a surge of for-profit businesses turning away business. I think it's a very unusual person who does that. I think it's mostly people are being performative and virtue signaling here in the short run. And I think that's also true of the other side. I can't imagine why somebody getting married wants a photographer who says they disapprove of you. I just would go to somebody else. I think on both sides of this is a temporary thing designed to go to court and not really a genuine cultural phenomenon. Now, there will be some people, there will always be some people, but it's going to be a small number.
And do we think that alternate dispute resolution services have a role to play in resolving these kinds of conflicts?
I'm sorry if I'm answering all of these, but I think that there's a lot of room for this. Very frequently in my experience, religious problems can be accommodated without terrible loss to either side if you have somebody willing to sort of explore ways to make it happen. Just one concrete example. This happened to happen during oral argument in court, but there was a case in the Seventh Circuit where the Illinois High School Athletic Association had a no hat rule for basketball, which that rule made perfectly good sense because if a basketball player is wearing a hat and it falls off, the players are not looking at their feet. They might, it's a danger. It's a safety problem. And yet the no hat rule meant that Orthodox Jewish boys were not able to play basketball, which is like a very serious, in the life of a high school kid, that's a very serious sacrifice. And in the middle, and the two sides were at loggerheads, and in the middle of the oral argument, Judge Posner asked the lawyer for the Jewish boys, he said, was there anything in Jewish principle that keeps you from putting a strap on the yarmulke? And so it turns out all you needed to do was just agree that you would wear a strap on your yarmulke and the problem goes away. This is, I'm not saying every conflict has a happy solution, but more of them do, I think, than we sometimes give it credit for.
All right, I think we'll on that note. Would that they all were so easy to settle as that one. Thank you, Michael. Thank you, Sarah. Thank you, Holly. Thank you, Dan, who had to leave. And Ali Kilsgard, who is the staff person who makes all of this possible at the ABA section of Civil Rights and Social Justice. Ali, thank you. I hope this has been a informative and interesting discussion. I certainly thought it was. And thank you all for being here. This will be posted on YouTube and on the website for the section. And I look forward to more such